Welcome to another episode of Lawyers for Immigrants with your host, Yifei He, president of the law office of Yifei He, where they are dedicated to helping immigrants and new Americans. In every episode, Yifei interviews attorneys across different practice areas and asks them how they are helping immigrants. You can find this show on YouTube, LinkedIn, Apple Podcasts, Google Podcasts, Stitcher, Spotify, and at www.yifeihelaw.com. Now here's the host of Lawyers for Immigrants, Yifei He.
Hi everyone, welcome to my podcast, Yifei He, where we put the grant in immigrant. On every episode, I interview non-immigration attorneys and ask them how their practice helps immigrants. And today, my guest is Ethan Ganc, the president of the law office of Ethan Ganc. Ethan is a specialist and a practitioner in bankruptcy law, and he's been practicing for over 20 years. I'm happy to have him on my show. So, Ethan, welcome to my show.
Thanks for having me, Yifei.
So, Ethan, tell us about your practice.
Yeah, so I've been practicing, as you said, for actually 21 plus years now, and I've had my own practice for the last 11 years. My primary practice area is indeed bankruptcy and creditors' rights, but I have a general business practice primarily, where I also work with general business advisory, primarily working with small and mid-sized businesses from startup to wind down, which is where the bankruptcy part comes in, as well as commercial litigation. But again, bankruptcy is my longest practice area, which I've been doing from the beginning of my practice, and remains the largest part of my practice.
Great. So can you define what bankruptcy is in layman's terms?
Yes. So very simply put, bankruptcy is a legal framework for addressing debt and it allows the debt to be addressed in a uniform manner.
Mm-hmm. I see. So in terms of how an individual would claim bankruptcy, what are situations when that would happen?
Well, let me actually throw in one other thing that maybe a lot of people probably don't know, which is that when I say it's uniform, the bankruptcy laws are federal laws and they are uniform throughout the United States, and that's a direct consequence of the U.S. Constitution. A lot of people don't know that Article 1 of the U.S. Constitution says that Congress shall have the power to set uniform bankruptcy laws, and there was in fact just recently just this last week a Supreme Court decision dealing with the issue of uniformity of bankruptcy laws. But your question was about how do you file for bankruptcy?
Yeah, in what circumstances would an individual such as myself encounter bankruptcy? Because it's not something that we typically think of when going through the day-to-day or even dealing with the law.
Right. Well, bankruptcy comes up for individuals in a number of contexts. And first of all, again, I work a lot with businesses and therefore small business owners, and so I'm often dealing with people who have businesses that may be struggling or may have gone out of business, and they have residual debt from the business, because a lot of small business owners, which of course includes many in the immigrant community, have smaller businesses, and in order to get any kind of credit in terms of loans, and oftentimes if they're signing a commercial lease, the principals, in other words, the owners of the business, are being asked to sign a personal guarantee, which is a contract by which they're saying they individually are responsible for the specific debts of the corporation or the business. And so oftentimes these numbers will be very large if the business has gone under or if it's struggling. And to avoid personal liability, oftentimes the principals will be forced or will decide that they want to file for bankruptcy. So that's one very common situation that I see quite a bit in my practice. And then, of course, you have just regular people who have consumer debts that may have gotten out of hand, or they may have experienced some kind of illness in the family where somebody couldn't work and the debts have gotten out of control, and they're looking for a way to address those debts one way or the other. And we can get into in a little more detail what some of the different options are, but I'll leave it at that for now.
Okay, so just to summarize what you just said, most of the bankruptcy that you represent is for small businesses.
Yes.
And
Yes,
this-
I primarily, although I do work with debtors who have consumer debt, my particular area of expertise is working with businesses who are in distressed situations. And I should also add, just for the record, that many times people will come to me. There's a common misconception that bankruptcy is a cure-all in all situations, and there may be situations where some kind of non-bankruptcy alternative is one that I counsel instead.
I see. So, but you did represent that a lot of your clients who are small business owners are immigrants. So, can you tell me more about your representation of these people?
Sure. Well, number one, what I'll say is, of course, the representation is the same as it would be for any other client. But one thing also that people don't tend to know is that bankruptcy is available to anyone who has a presence in the United States. You don't have to be a U.S. citizen to be qualified to file for bankruptcy as an individual. And in fact, I have represented many people who are merely green card holders, but who are living and working in the United States and have debts that have accrued in the United States that they need to address.
I see. So, what is like the main difference between representing someone who's a U.S. citizen versus someone who's a non-citizen in terms of bankruptcy law?
There is absolutely no difference. Again, the laws are uniform, and assuming that the person is eligible, and everybody's eligible for some kind, but assuming that the person can do what he or she wants to do in terms of a bankruptcy option, it's exactly the same whether you're a green card holder, whether you're a citizen, and frankly, even for undocumented immigrants. I mean, that bankruptcy filing could pose other problems, but in terms of eligibility and the process itself, it makes absolutely no difference, regardless of a person's immigration status.
Let's see. So, what kind of problems might an undocumented individual face when filing for bankruptcy?
Well, an undocumented individual, bankruptcy, the quid pro quo for filing for bankruptcy is that there's a lot of disclosure of in this case, we're talking about individuals' assets, liabilities, financial situation, financial past, and among other things, there is documentation that has to be provided, including tax returns and social security numbers. So proof of social security numbers. So in the event somebody was undocumented and doesn't have a social security number for obvious reasons, that's going to pose a challenge for them.
So, are they still eligible for bankruptcy even if they don't have a social security number?
They are technically eligible, but I believe it could be problematic.
What kind of problems do you see someone encountering if the business is just struggling? They can't keep on. They might have been employing 10 U.S. workers, but they're undocumented. So, and their business is losing too much money.
Well, of course, what we're talking about here is an individual bankruptcy, and there may be options for the business itself. If the business is a separate legal entity that's formed in the United States, that could potentially file, depending on the circumstances, that might potentially be a business that files for bankruptcy. I mean, we need to differentiate. Bankruptcy is an option that is available both for individuals and for businesses. And so depending on the circumstances, it may be that the business can file and not the individual.
I see. And what are the benefits of filing for bankruptcy?
So the most immediate benefit is that as soon as you file for bankruptcy an automatic stay goes into effect. And what that means is, as the name suggests, automatically, there's no court order required. As soon as the bankruptcy petition is filed and you get confirmation the bankruptcy is filed, no creditor can take any action to collect upon debt that arose prior to the bankruptcy filing. So if there are lawsuits, they stop. Any kind of demands, you can do absolutely nothing until that debt is addressed in some way through the bankruptcy proceeding, or the bankruptcy proceeding at some point ends. If the debt is one that survives a bankruptcy, and that's something we can talk about at another time too. But that's the main power of bankruptcy. And again, what bankruptcy, there are two. Let me just, because we're talking about some things where I haven't really gotten into the two options available for individuals, or the two major options. One is Chapter 7, which is a liquidation proceeding, and in that it's a much simpler proceeding, in that there's no repayment of any debts. If the debtor has certain assets that are within the reach of creditors, rather, there's a third party called the trustee, whose job it is to determine whether there are any assets, if there are, to liquidate them for the benefit of creditors, and to distribute those assets in accordance with the priorities in the bankruptcy code, because not all debts are created equal. But there's no repayment plan, and not all assets are subject to liquidation and distribution by trustee. There are a number of assets, basic assets, that are protected by operation of law, and I can get into that in a second. But let me talk about the second kind of bankruptcy, which is a repayment plan, known as Chapter 13. Chapter 13 is a wage earner's repayment plan, and basically I'm oversimplifying a little bit for purposes of this conversation, but basically what happens is you have the debtor, the entity that files for bankruptcy, proposes a plan, and you say, I'm going to pay my excess monthly income. It's for either, depending on what your income is. If it's below median, it's a 3-year plan. Or if it's above median, it's a 5-year plan. But either 3 years or 5 years, you pay your excess monthly income into a plan, and after you make all those payments, then your debts get discharged, which means forgiven.
I see. So how do you know which one to file? 7, 13. There's also 11, I believe. So what?
So 11 you see mostly in the context of businesses. It's a reorganization typically, but it's much more complex and therefore much more costly. Now, individuals are eligible to file for Chapter 11, and there is a debt limit for Chapter 13s. There's just some new legislation, hasn't been signed. Literally yesterday, that was just passed by the House. That's going to change the debt limits, but assuming President Biden signs it, and I have no reason to believe that he won't, there will be just a regular $2.75 million threshold. There's a distinction between how much unsecured debt you have and how much secured debt you have. It's just going to be a flat ceiling that says if you have less than this amount of money, this amount of debt, then you're eligible to file. And so if you have more, then let's just assume it's going to get signed into law. If you have more than the $2.75 million in debt, you wouldn't be eligible to file for Chapter 13, and you'd instead have to file for Chapter 11. But individual Chapter 11s are, for most people, are fairly rare.
I see. So again, if you're an immigrant, you don't know about your laws or you don't know your rights. How do you know which chapters to file under?
Well, that's where speaking to an attorney who can advise you on what the benefits are and your eligibility to file for the different options comes in. Because just because you're eligible for one versus the other doesn't mean that one is necessarily in your circumstances going to make more sense versus the other. Let me give you a good example. Chapter 13 is great for people who have mortgage arrears, manageable ones, or arrears on some other kind of contract, like could be a home lease, a car lease, or something like that. Because Chapter 13 allows them, as long as they continue to make the regular monthly contractual payments, they can pay the arrears over the life of the plan. So remember how I said that a plan is 3 years or 5 years? Mm-hmm. So let's just say you have a car lease and you didn't make a couple of payments, and let's just say, I'm making up numbers, you're $5,000 behind in your car lease. Now, normally, under the terms of the contract, that is likely going to mean that you're in default and they can accelerate the lease, which means they can say all the money is due now and you have to pay it all, or something like that. In a Chapter 13, you can, notwithstanding what the contract says, you can say, you know what, I'm going to continue to pay my monthly payments of, again, I make up a number, $250, and the $5,000 that I'm in arrears, I'm going to pay it off over the life of the plan. Let's say it's a 3-year plan, over the 3 years, and it's going to get paid in increments as part of the payments that are made under the plan. And at the end, assuming that all these payments are made, you force the creditor to accept that catch up. And there's nothing the creditor can do as long as you meet all the requirements of confirmation for a Chapter 13 plan. It's very powerful. And again, it can be used with mortgages too. Obviously, if the number is too big, that can be problematic because you have to be able to pay it off in either 3 or 5 years. But for smaller arrears, it can be very powerful. Similarly, if you have a contract that you don't want, both Chapter 7 and Chapter 13 can allow you to reject the contract, even though normally the contract says you can't cancel it. And whatever monies are due are still due, but they would get lumped into general unsecured claims that either in a Chapter 7 plan may not get any distribution at all, or in a Chapter 13 plan will get whatever distributions they get based on payments under the plan. But if there's a lease that you really think is burdensome to you, bankruptcy can be a very good option for you.
Okay, so I mean, assuming for the perspective of an immigrant who don't have connections to the U.S. and who don't plan on staying to repay their debts, wouldn't Chapter 7 make more sense if, for example, they had a business here and the business is actually making money, but then they're just trying to wind down the business? So in that case, there would be complete business liquidation. There would be no repayment plan. So basically, they just divide up the business to pay off the creditors. Wouldn't that be the most applicable chapter for bankruptcies for immigrant business owners?
Well, so Chapter 7, depending on the nature of the debt, Chapter 7 is subject. There are eligibility requirements. Now, if the person's debt is primarily business debt, there's no eligibility requirement. And so, if this hypothetical immigrant doesn't really have any property in the United States, anywhere, doesn't have any property, then Chapter 7 is certainly the easier way. But this is something that's decided on a case-by-case basis, depending on what the liabilities are, what the assets are, and what the issues are that the person or persons are trying to address. And I should also just say that in terms of bankruptcy, married couples can but are not obligated to file jointly. So if you have a couple that shares debt, they can both decide to file. But equally, if you have a couple where one spouse has all the debt and the other, for whatever reason, doesn't want to file, it's not It's not an obligation that the spouse doesn't owe any money file. But there in most situations, people more often than not, spouses tend to share some amount of debt. But again, it's all going to depend on the facts and circumstances of the case. It's very hard to answer certain questions in a vacuum, just because all of these answers are very fact specific.
Right, right. No, definitely. If someone wants to file for bankruptcy, they should definitely consult with an attorney
It's
instead of just picking something out of the.
yes,
Right.
yes, and Yifei, I do want to say that there is also this misconception out there that bankruptcy is just a question of filling out some forms and it's very easy and you can do it without a lawyer. That's a recipe for disaster, and it can be a major trap for the unwary.
Okay, and what kind of traps have you seen? What kind of consequences have people faced from DIY, like LegalZoom?
I can tell you one that sticks in my mind very, very clearly, and this actually, it so happens, had to do with an immigrant family. One of them, they owned it happened to be a Chinese restaurant, and the restaurant failed, and so one of the owners filed for Chapter 7 himself. And as I said, in Chapter 7, what happens is there is a third party who's called the Chapter 7 trustee, and the Chapter 7 trustee's job is to see if there are any non-exempt assets, if the person owns anything that's outside the reach of, that is within the reach of creditors, rather, and if so, to liquidate that and distribute it, as I said before. Now, that includes obvious things like money or money above a certain amount, and any kind of tangible assets. But there are causes of action that arise under the bankruptcy code or under state law that the trustee has a right to assert in a bankruptcy case. And one of the major causes of action, and this exists under state law, but under state law, creditors have to bring action, are what are called fraudulent transfers. And I'm oversimplifying for purposes of this conversation. They're actually known now under state law as voidable transactions, but the concept is the same. Transfers of assets without adequate consideration, in other words, for less than fair market value, within a certain period of time. Under state law, it's 4 years prior to the bankruptcy, and under bankruptcy law, it's 2 years prior. So in other words, if a person, let's say, transfers, let me give you a more concrete example, just rather than say person. So let's say I own a business in my own name, and I have a company car. And I see that my finances, or the business finances are not good, and their creditors knocking at my door, and I have some assets. Let's just say I have a company car. I don't want the creditors to get the company car, so I call a friend and I say, I will sell you the company car for $20, so that when I file for bankruptcy or when I have financial problems, it's not going to be in my name. So I sell my friend the car for $20. So assuming that happens within the applicable look-back period, the trustee can come and say, hey, wait, to my friend, you have to give back the car or the value of the car, because the car was worth more than $20. So you have to give back either the value of the car or the amount of money that you got over and above what was paid for. And let's just say the car's worth $10,000. And so trustees, now that's a very concrete example, but trustees are going to look at compensation. They're going to look at all these sorts of things. And even if nothing winds up being a problem, there's going to be a lot of scrutiny of the individual. And in this case, the individual just filed, and there was a transfer that was, that looked questionable to the trustee. He thought that it might be a fraudulent transfer, and so he sued the guy, and I wound up having to represent him. He didn't hire a lawyer going into it, and a lawyer would have told him, assuming he had disclosed it to the lawyer, this is a potential problem, and so maybe you want to wait, or maybe you want to think about doing something else. He wound up having to spend a lot of money defending himself in a lawsuit that was brought against him, as well as other parties who had received the transfer.
Well, that's
so just to finish the thought, it can wind up costing you. It's a typical example of penny wise, pound foolish, where you think you're saving yourself a few bucks by not hiring a lawyer in the beginning, and he had, first of all, many more headaches, and I can tell you, he spent a lot more money on the other end of things that perhaps he could have avoided had he sought counsel beforehand.
I see. Well, as you can understand, a lot of individuals, when they're seeking bankruptcy, don't have a lot of financial resources. So it's very difficult for them to actually proactively seek help, try to get a lawyer who they might not even be able to afford. So what do you do? How do you solve the problem between the access to justice gap?
Well, so understand that a lawyer has to get paid for his work. There's no two ways about that. But obviously, there are in a bankruptcy situation, either in 7 or 13, these are typically done on a flat fee basis, for the very reasons that you said, that people don't have the funds. And one of the other things is that in a Chapter 13, a portion of the fee, unlike in a 7 where the fee has to be paid in advance because otherwise it will get discharged as well, in a 13, a portion of the fee can be paid through the plan as well. So in other words, the monthly payments that are made under the plan, which are distributed to creditors, as I've said before, in order of their priority, the lawyer can also be a creditor, and the lawyer is a priority creditor. So the lawyer will get paid whatever the agreed upon portion is over the course of the plan. So sometimes there are people who, if they can't afford, for example, if they can't afford a Chapter 7, they will sometimes do a Chapter 13. Although that's not a strategy that I like to employ, but I know that that's done sometimes for people who are really in an extreme situation. But understand that if the situation is really dire, Chapter 7s tend not, they're not, they're not as expensive as you might think.
Right. No, it's always good to not be penny wise and pound foolish. And
Right.
in that case where you mentioned, where the Chinese restaurant actually did it themselves and they got sued later for making mistakes, it would have been far wiser for them to have consulted with the lawyer, at least for initial consultation, as opposed to having to chain them for a whole bankruptcy filing. They're just trying to do them themselves and getting sued.
Without question, it was a big mistake, and that, really, that's the biggest cautionary tale. And fortunately, at the end of the day, it turned out okay for this guy. But what he thought was going to be a very simple process was this literally was litigation, and it is litigation, just so that we're clear, i.e., a lawsuit filed in a federal court. The litigation took years to be resolved.
Right, and not many people know this, but you can also face potential federal criminal charges.
There are criminal, because bankruptcy requires full and complete disclosure of assets and liabilities. There have been some prominent people. A lot of people have heard of the one of the housewives of New Jersey, Teresa Judas. She and her husband were both convicted of bankruptcy fraud, or her husband at least. I don't know if she filed for bankruptcy, but the point is they didn't disclose certain assets in a bankruptcy filing, and that's a big no-no. There are a lot of benefits from filing for bankruptcy, but again, the quid pro quo is that you have to be completely truthful and honest, and you will be asked questions. Some of them may be uncomfortable, and you will have to disclose your financial situation to the world, and these are publicly available documents.
Okay, well, thank you a lot, Ethan, for appearing on this show. As everyone can readily see, Ethan is very knowledgeable about bankruptcy law, so I encourage all our listeners to reach out to him if they have any questions about bankruptcy law, if they have a troubled business. And so, yes, be sure to check our show out next time, available on all major streaming platforms. Thank you very much.
Thank you.
You've been listening to Lawyers for Immigrants with your host, Yifei He. You can find prior episodes on YouTube, LinkedIn, Apple Podcasts, Google Podcasts, Stitcher, Spotify, and at www.yifeihelaw.com. Thank you for your positive reviews, comments, and sharing this show with others.